कदमों में है आसमां, है मुट्ठी में ये सारा जहां।
सपनों को हकीकत बनाना सीखा है हमने यहाँ।
पीछे मुड़ के देखा नहीं, बस हम आगे बढ़ते ही चले।
राहों की सभी मुश्किलों पर जीत करते ही चले।
यहीं पर है तराशा अपनी किस्मत को हर पल। हम अपनी कदम से है लिखते अपना आने वाला कल। रहना
Uttaranchal University, Uttaranchal University, Uttaranchal University, Uttaranchal University.
Uttaranchal University, Dehradun, for the excellence within you.
Respected keynote speaker of the event, Mr. David Boyle, Barrister, Dean's Court Chambers, Manchester, United Kingdom. Respected Vice Chancellor, Dean, Law College Dehradun, Uttaranchal University, Professor Dr. Rajesh Bhavna sir. Respected Principal, HOD Law, Law College Dehradun, Professor Dr. Poonam Rawat ma'am. Participants from all across the globe, ladies and gentlemen, a very pleasant afternoon to all. I, on behalf of Law College Dehradun, Faculty of Uttaranchal University, welcome you to this edifying international webinar on the topic, A Guide to Dispute Resolution Processes. Taking the event further, I request respected Vice Chancellor Sir to kindly welcome and introduce the keynote speaker.
Thank you, Nana. On the occasion of this international webinar on the topic, A Guide to Dispute Resolution Process, today with us are Mr. David Boyle, Barrister, Dean Court, Chambers, Manchester, England, Principal of Law College Dehradun, Uttaranchal University, Professor Poonam Rawat, President, Secretary, and all the office bearer of Training and Recruitment Division, TRD of Law College Dehradun, particularly those who are in front and taking the lead of organizing it, Ms. Nana Bhatt, Ms. Akanksha Bhatt, Rashi Jha, and all other office bearers. More than 1,500 registered candidates. All the candidates on board. My dear participants, I extend my greetings to all of you on this occasion. I am also taking this privilege to welcome you on the behalf of Law College Dehradun, Uttaranchal University, on the behalf of Devbhoomi Uttarakhand of India. You all are welcome here. Ladies and gentlemen, I am expected to introduce today's keynote speaker, Mr. David Boyle. But let me tell you very frankly, introduction of Mr. David is not new to the legal luminary, particularly those who are in this field. But still, if it is asked, so instructed in equal measures by claimants and defendants. David Boyle has thriving practice across a broad spectrum of complex, high-value, high-profile, and unusual multi-track claims. Always approachable. He has a particular appreciation of the need of client to understand their litigation, no matter what the complexities, and has a reputation for both clarity and forensic rigor in both his written and oral advocacy. He is regularly instructed to appear at joint settlement meetings and mediations as well as trials. and is in demand, giving seminars on all aspects of personal injury law. He has been visiting lectures at the University of Durham, Lancaster University, Liverpool John Moores University, and the College of Law. He was head of mini pupillage at Dean's Court from 210 to 216 and was in 219 the first personal injury barrister ever appointed to the Bar Standards Board's associated pool of experts, advising the BSB as to the appropriate conduct of barristers practicing in civil law. In 2014, he was invited to debate at the Cambridge Union alongside Mr. Matt Jason, Fellow of Trinity College, Cambridge, defeating a team consisting of both the winner and losing finalists from the European Debating Championship 2013. His speaking engagements in the last 3 years have included the Grand Annual Conference, Liverpool Law Society Occupational Disease Conference, the Motor Accident Solicitor Society MASS Annual Conference, and a variety of bespoke in-house conference and training sessions. His books include On Experts in 2016, An Introduction to Personal Injury Law in 2017, and the Mini Pupillage Workbook in 2019. He is currently working on his fourth, that is COVID-19 and personal injury law. Wonderful. Fifth, case management, and sixth, forensic thinking books, which might explain why his publishers are still waiting. David is regularly instructed in fatal accident claims and injuries of utmost severity. He has a particular expertise in accident reconstruction and cases on accident abroad. He has specialized in civil fraud litigation for over 20 years and undertakes all aspects of industrial diseases work. He has brought successful action against the Home Office, Ministry of Defense and Health, and Safety Executive and represents a number of high-profile clients. His perceptive and analytical approach makes him the first port of call for non-standard cases. And above all, what I could find within a very short meeting, a thorough gentleman, and that is what a scholar needs, beside his all academic qualification. Ladies and gentlemen, today's topic is a guide to dispute resolution process. And now in fact, time has come in India as well as all over the world to go for an alternative dispute resolution system for the region, so many regions. And even the law students, they must understand that in all over the India, including India, we will have now the system of litigating and non-litigating lawyers. And the alternative dispute resolution mechanism, whether it's arbitration, conciliation, mediation, reconciliation, etc., they will have a good scope. So we are really fortunate to have an expert on this side today, Mr. David Boyle. So I'm not taking much of the time. I very humbly request that to give the presentation, Mr. David Boyle. Please, sir.
Professor, thank you so much for those very kind words. Let me just make sure that I can share this screen with you. And I hope that you can now see my slightly less handsome face with a beard and my slides for this morning. Today's topic is one of alternative dispute resolution as well as dispute resolution. And I had the huge pleasure of sitting in last week as you received a talk on the difference between mediation and arbitration. So I thought I would start off by talking about, whoops, forgive me, dispute resolution. And there is a very easy way to avoid dispute resolution, which I think is evidenced by this slide, because on Wednesday, my parents celebrated 50 years of marriage. And if you look at the photo on the right-hand side of your screen, my father is now 81, my mother is now 76. 50 years has done them, I think, the power of good. And on their silver wedding anniversary, my father said that the art to a happy marriage can be distilled into 2 words: yes, dear. And that idea of avoiding dispute is, of course, something that would be wonderful in this world, but would put all the lawyers out of business. So today I want to talk about alternative dispute resolution, the way in which we can resolve our problems without going to court. And there are a number of different ways that we can do that. And I give some headings here: arbitration, mediation, joint settlement meetings, and simple negotiation. And I want to touch on all 4 of these topics today. But I'm aware that I'm talking to people from all around the world, and in particular from people in India who may not have come to Manchester and who may never get the opportunity to come to Manchester. So I thought I would start by giving you a whistle-stop tour of some of the more important places. Not my house, not my study. You can see that behind me. But I thought I would start today with this picture, because when I started in practice 25 years ago, this was the county court in Manchester. And the road that you can see in the foreground is Deansgate, which is a road that has existed in some shape or form for 1,000 years. And this was the old county court building, 184 and 186 Deansgate. Two different buildings, 2 different addresses, but 1 full county court. And we can see, this is the entrance over here, if you can see my mouse, to 184, and this is the entrance with the green door to 186. And these days, it's changed, because it's now the Hawksmoor restaurant in 186, and there is a burger bar or other fast food place in number 184, which is interesting because this is as much as a courtroom now, where you can in fact talk and meet and engage in alternative dispute resolution. And the food is very good. But most of the time, as lawyers, we are expected to go to court. And this is our new court building in Manchester. It's designed to look like a huge filing cabinet. And you can see to the right of the screen, this is the River Irwell. And the second city of Manchester, Salford, is over to the right-hand side of the screen. And the square white building to the left-hand side is the Crown Court. And my chambers, if you can just see to the left of the crane on the very left-hand side of the building, there's some red brick buildings just on the very edge of the photograph. Those are where my chambers are. If you're a football fan, Old Trafford, which is obviously the only football ground in Manchester worth visiting, it is directly behind this court building, and we are looking across in this photograph all the way to Wales. This is a statement on the part of Manchester that we are open for business and we look forward to being able to litigate. Personally, I think the court looks better at night. I think most buildings look better at night with the lights on. And this is the front door of my chambers. Because today, as we talk about alternative dispute resolution, a lot of the conversations that we have and a lot of the negotiations that we have take place in chambers. We invite people into our professional homes. And now in the time of COVID-19, we invite people into our own homes. We now have our meetings by Zoom or other media platforms. And every so often I look around me at the things that you can see in the background of my webcam and think, should I get some artificial background? Should I tidy up the place a little bit? But actually, we are human beings and we are engaged in negotiation and we are trying our best for our clients. And having an approachable face, it is an absolutely key part of those talks. So what I wanted to do at the start, before we get on to the nitty-gritty of alternative dispute resolution, is to talk very briefly about mindset. Because one of the things that I've always struggled with talking with students is how we teach. Because when we are learning, when we're very small children, we start by learning what we're supposed to be doing. Can we press the button? Yes. What do we do? We press the button, press the button. And after a little bit, we teach people how to do that task, how to press the button, perhaps with panache and style. But we teach what we do, and then we teach how we do it. And eventually, if we're lucky enough, we start thinking about, that's a very, very difficult step to take, because we've used an awful lot of our energy on what we're going to do and how we're going to do it. And if we're not careful, as we go outwards towards the outer regions of our circles, we go too far. We go into the wasteland where there are monsters and dragons and all sorts of intellectual complexities. So what I say to my students is this: if we start by asking ourselves the question of why, and we put up a boundary against the wasteland and the dragons and the monsters and all the difficulties that might assail us when we start thinking too hard, and we face inwards, we can put up that boundary and we can focus our attention, and we're using the first 5% rather than the last 5% of our mental energy. And we think about why we're engaging in the act that we're doing. Then we can concentrate on the how, and then we can concentrate on the outcome. And that is really important in the context of alternative dispute resolution, because if we think about our why are we going to do this, then that in itself will drive how we approach the exercise, how we approach the analysis, and that in itself will give us a better chance to focus our energy on getting the right outcome. So I wanted to talk about what we are trying to achieve in these cases. And I have rules of three. I like three, I much beyond three. And I see so many numbers today joining us. It's fabulous to see so many. But once I get beyond three, I think of them as many. So I have a rule of three for my claimants. And this is a photograph of my left hand. I always use my left hand for claimants and my right hand for defendants. I'm not quite sure why, but I've been doing it for nearly 25 years. And the rule of three for claimants is this: I want to get my client as much money or as much as possible, doesn't matter whether it's money or whatever, the best result possible. But I also want to get them that result as quickly as possible. And I also want to do it with as little risk as possible. So as much as possible, as quickly as possible, with as little risk as possible. But the secret is this: you can't have all three. There is always going to be a trade-off between getting the best result and doing it now and minimizing the risk. Because if I could get you £1 million tomorrow with no risk, then I wouldn't be doing this job anymore. I'd have bought myself an island in the Caribbean and I would have retired by now. But understanding those drivers of behavior for a claimant or from anybody who's hoping to take something from a negotiation, is a critical starting point. And every time I meet a client for the first time, I use this assessment to explain to them that there is not going. Of course, there's also a rule of 3 for defendants. And in this case, I'm talking about somebody who is looking to pay some money. And of course, we could just use the same argument, but in reverse. I want to pay you as little as possible, as quickly as possible, with as little risk as possible. But it's more nuanced, because my rule of 3 for defendants is about why they should fight a trial. Why should they not settle a case? And this time I'm using my other hand. And this time, the first reason to fight a trial is to discourage the next claim. Because you might have a unionized workplace. You might have 100 or 1,000 claims all piled up, waiting to have their day in court. And putting down a marker to say, I will not settle, I will push, I will fight, can be a political statement on the part of the defendant, trying to set an agenda, not just in this case, but across the board. And the second category of cases that fight to trial are those where the differences between the two parties are simply irreconcilable. I had a case last year where if I won, my case was worth £650,000. And if on the defendant's case, it was worth £1,000. Now, the difference between £1,000 and £650,000 is huge. And if they had offered us £150,000, my client would have accepted that, because that is too much money to walk away from. You can't leave a cheque on the table for £125,000 and pretend that nothing has happened. That is an amount of money which changes lives. But they offered us £30,000. £30,000 for a life where, for a 35-year-old lady, she was never going to work again. And that was not enough. Our differences were irreconcilable. So that is a category 2 case. And there is a third category, the case that gets to court because nobody remembered to settle it. And they say, well, we're here now. We're here. We might as well. We're outside court. The judge is ready for us. We've spent all the money. Let's go in and fight. And those are our 3 cases, or categories of case, where defendants fight a trial. And every so often somebody says to me, I have a new 4th category of case. A 4th category, I say, is it that the solicitors hate each other? And of course, that is the answer. That's always the answer, because they think that they've reinvented the wheel. They think they've come up with a new idea as to why a case will fight. And then I explain to them that if the lawyers hate each other, then suddenly they want to make a political statement to discourage the next claim. And all their differences become irreconcilable. And because they won't talk to each other, nobody ever thinks to settle. And this 4th category is in fact a combination of the 3 that I've already identified. And those 2 rules of 3 drive our behaviours when we try to settle cases and we try to fight cases. And it's important that we understand the interchange between that. Because from a defendant's perspective, if they want the claimant to accept some money, they introduce some risk and they offer a settlement now for slightly less money than the claimant wants, in the hope that they can get it settled. Sometimes they can't do that. Sometimes the claimant wants to have his day in court. But if we start off by understanding these drivers of behaviour, we can then start thinking, that's our why. Why are we trying to engage in our ADR? Then we can start thinking about how we are going to do it. So we come back to this slide about the different types of ADR. And The first one is arbitration, and we talked about arbitration last week. And one of the issues with arbitration is that it gives the parties control. What is arbitration? Arbitration is this quasi-judicial determination of the case, just as if it was going before a judge, but not in front of necessarily a judge. A party that the parties to the litigation choose to be an arbitrator, somebody who has a particular knowledge of the issues in question. They don't have to be a lawyer, although it helps to have some sort of legal qualification. And normally arbitrators have a formal certification. But it gives the parties control over the system. They get a specialist tribunal. They get a binding determination. They get a resolution. They might not like it, but there is a finality to it. Now, that can be a costly exercise because a big arbitration can have all the hallmarks of big litigation, but it allows you into a fast lane. It allows you to bypass the traffic jam of cases, because as we come out of COVID-19 lockdown, we are going to find not just days of backlog or months of backlog, but years of backlog. And we are going, I was talking to somebody yesterday who told me that they estimate in the United Kingdom is that there are 500,000 magistrates' court cases now waiting to be determined. 500,000 cases. And the only way that we can see that happening, presumably, is to have magistrates running in shifts. And they won't be able to do 8-hour shifts. They'll be having to do maybe 6-hour shifts and doing 24-hour courts. Because otherwise, we are never going to catch up. And ADR is going to become more important for the civil litigation. But of course, ADR is not available in the criminal context, where you have a state prosecuting an individual for committing a crime. I've jumped ahead to the end point of negotiation, because as lawyers, we forget sometimes that we can just pick up the telephone. We can just send an email or a letter to the person on the other side, because that person on the other side wants to get their file off the desk just as much as you do. They want to resolve it. They don't need to be working on this particular case. They are going to be perfectly happy to get this one done and move on to the next case. And negotiation takes a lot of different forms. You can simply send a letter saying, this is my offer, take it or leave it. But you can also have face-to-face or telephone or Zoom conversations where you actually have the opportunity to have a bit of a chat, catch up with people. From barristers' perspectives, very often I'm against old friends, people who I've not seen in 2, 3, 5, 10 years. And you pick up the phone and the first 10 minutes or the first half hour is actually spent talking about the weather and friends and what you did last time round, because it's part and parcel of oiling the machine, getting those negotiation cogs moving, so that we can then say, let's cut to the chase. How much do you want? How much do I need to pay you to go away? This is how much my client's prepared to give or take in this particular exercise. And sometimes negotiation between lawyers, it's gone out of fashion, but it's the easiest way to actually settle a case without formality. Meet for lunch. 20 years ago, an insurer would take 20 files and he would go to the solicitor's office and say, right, let's talk about not one case, but about 20. I'll give you this much on case 1, this much on case 2. Do you want to settle case 3? And if after an hour and a half, he'd settled 10 of the 20, that was a good morning's work. Far quicker, far more effective, far more personal than writing a letter, pressing a button on the computer. But the other two aspects are more formal aspects of negotiation: mediation and joint settlement meetings. And they are very similar in a lot of ways. This is with a joint settlement meeting, a without prejudice meeting between the parties or their representatives. And you have the representatives there, and you have both sides in advance. Normally, you'd like to think it was going to happen in advance. Sometimes you turn up and you're taken by surprise, but in advance, both parties provide a position statement, and that can be a formal schedule of your claim. It can just be a typed note, an email saying, look, these are the points that we want. This is what we want. This is what we're prepared to agree. And for these purposes, today's negotiation, we're prepared to concede X and Y and Z, but I'm not giving you this and I'm not giving you that. So you have position statements exchanged purely for the purposes of the negotiation. And that means that you don't have to deal with all of the issues. You can deal with some of the issues. You can deal with all of the issues. You might end up not dealing with any of the issues. But what's important when you're having a negotiation is that you can come to a conclusion which is not open to the judge. Sometimes a judge has to make a binary decision. If this had happened, what would the outcome have been? Would it have been X or would it have been Y? But when you're negotiating an answer, you can take account of the fact that there's probably a 60% chance he will find X and a 40% chance that he will find Y. But you are looking at a settlement which is somewhere on a bell curve. It's not an either or when you come to have that negotiation. And that is one of the huge benefits of ADR rather than going to court. And that means that sometimes you're not bound by the precedent. You might want to use the precedent. You might want to use the law and say to your opponent, well, hold on, if I go to court, this is going to be the answer because this is what the law says. But the response can be, yes, but we want to change the law. We want to go to the Court of Appeal. We want to go to the Supreme Court. We want to try and change the law. And we're going to turn this case into a test case that binds the industry, that binds other people. And then you can turn it into a negotiation because one side or the other might not want to go to court and lose. And in a JSM, costs can be dealt with as well. It may be a case where you can agree an order for costs. You can agree the precise figure for costs. You might agree to let the court determine costs at a later date. So what's the difference between a mediation and a JSM? Well, it looks pretty similar. You just have a mediator added to the mix. You have a referee to stop the barristers beating each other around the head, or alternatively, nipping off and having a cup of tea and chatting for 3 hours while the clients get very bored waiting for them. But a mediator can help cut through the issues between the parties and give a time scale and a tempo to the negotiations that's a bit different. Now, in my practice, the overwhelming number of cases are joint settlement meetings. We take the view that we're grown-ups, that we know what our answers are, we've got a good idea, we don't need a mediator to hold our hands and say, now, play nicely, because that takes us back to the playground. But a mediator can bring specialist knowledge. A mediator can say to a client and reach out to a client past the representative sometimes and say, look, this is about you. Don't feel that the lawyers are in a little cabal trying to stitch you up and get some decision that works for them and not for you. Don't worry about that. I'm here to make sure that there is fair play. And that can be hugely beneficial if you have a situation where there are personality clashes, either between the lawyers or between the parties themselves. The mediations that I've done that have worked well are where there is a real animosity between the parties, not the lawyers particularly, but between the parties, because of the nature of the events that gave rise to the claim in the first place. And when there is a lack of trust, then having an independent mediator in play has that sense of distance, but also in balancing the outcomes. And to give you an example of one of these cases, I had an awful case a few years ago where my clients, two clients, were sisters. And one sister was going into kidney failure. She needed a kidney transplant. And she was one of 6 siblings. And 3 of the siblings said, well, test me to see whether I can donate one of my kidneys to save my sister's life. And my other client was the lady who ticked the most boxes. She scored 6 out of 6 on compatibility, and she gladly gave up her left kidney to save her sister's life. But she didn't make a quick recovery. It's a big operation, but she kept on getting infections. And they couldn't work out why she kept on getting infections. And they kept on scanning her and doing tests. And then they realized the problem was that she had a cancerous tumor on her right kidney. And she'd given up her good kidney and been left with a bad kidney. And they operated, they removed half of that remaining kidney. She was in a reasonable state considering all the circumstances, but she was so very angry that it had not been picked up when they did the original scan. And there was an awful irony that had she not donated her kidney, her sister might be dead. And had she not donated the kidney, they wouldn't have spotted her cancer in time. And by the time they realized there was a problem, it would have been too late and she would have been dead. But telling your client that they could have been dead and that's why they were angry is not a good way to establish trust. And it was quite clear in that case that the hospital who admitted liability were seen as being utterly evil as far as my client was concerned. I don't think she thought very nice things of me either, to be honest, because I was trying to say, well, we need to resolve this and we need to put it behind us, and spending the next 12 or 18 months obsessing about litigation is not in anybody's interest. But by bringing in a mediator, we could facilitate a settlement that might not otherwise have been possible. So I wanted to talk about approaches to ADR because I was invited to talk about ADR processors, plural, and I think I've done that now, but with a lovely audience, and I just look across and see that there are 631 people on the line. Thank you ever so much for showing up on a Friday afternoon to listen. 631 of you. This is the point where the number 632, somebody's late to the party. This is where they suddenly go, oh, we've heard all the good bit, we're going home now. But I wanted to talk about not just ADR processors, but I wanted to talk about the ADR process, what we actually do within ADR and how we approach it to try to get the best results for our clients. Because we've already talked about the approaches and the drivers of behavior in these cases. But it's really important before you pick up the telephone, before you go into the conference, before you start in the mediation, to know what you need, know what you want, know what you'd like, and know what you'll concede. These are rules for life. These aren't just rules for ADR. These are rules for what we want in life. What we need, what we want, what we like, and what really isn't important to us. But addressing those issues with your client before you start, and even if you can't get an answer, but identifying the need to think about those issues before you start is going to make your life much, much simpler. Manage expectations, though, is the absolutely key point. I'm afraid that we can't all drive Lamborghinis. We can't all live in a mansion. We can't all have widescreen televisions. We can't all have all these trappings of 21st century life, much as we would like to. And as I said before, these are approaches to life. What we need, what we want, what we like, and what isn't important is all part and parcel of our expectation in life as in litigation. So in advance of the ADR, whether it's a mediation, negotiation, joint settlement meeting, whatever it happens to be, you need to know your case. You need to establish in your own mind your narrative. And that means that you build the bridge. You build from A to B. This is where I am. This is where I want to get to. And I put in place those building blocks to get across to where I want to be. And to do that, I need to know what information and what evidence I have available to me and how it will support my position. And I need to know my opponent's case. It's Sun Tzu, know your opponent, know your enemy and win 10,000 battles. Yes, of course it is. These are patterns of history that repeat themselves. Understand the weaknesses in your case because they will probably correlate quite well with the strengths of your opponents. I remember being taught this in negotiation at bar school. And somebody said, think of your good points. Think of your opponent's good points. Think of your bad points. Think of your opponent's bad points. And they probably match up. And I'm thinking, of course they match up. If it's good for me, it's not going to be good for them. Know your opponent. Sometimes you're against an old friend. Sometimes you've never met this person in your life before. But that doesn't mean that you're not going to be friends by the end of the conversation. And you can do your research on your opponent before you start. You can look them up online. You can see what they say about them. You can see how they put the website entry. You can see whether people damn them with faint praise. You can speak to your friends in chambers. You can speak to your lawyer. Do you know this person? What do you know about them? What are they like? You can pick up the phone in advance and say, we're having a meeting on Friday. I'm going to organise some food. Are there any particular types of chocolate biscuit that you like? I'll sort those out for you. Because that is how we get people talking. Know your mediator. If you've got a mediator, find out who they are. Are they the right person? We talked before about personality and a lack of trust and how a good mediator can bridge those gaps. Knowing your likely judge is really odd in the context of talking about alternative dispute resolution. Because that's the alternative. And you're focusing on trying to settle the case. But we need to understand that the grass may be greener on the other side. We might know that we're going to get this particular judge. It might be on a particular judge's docket for the trial. And we know that that's the judge we're going to get. And we know what his prejudices are. We know what his likes and dislikes are. We might know that I've never won a case in front of him in 20 years of trying. And that was one of the difficulties with my £650,000 case. I was in front of a judge that hasn't found for me ever. and trying to say to your client, yeah, well, I'm bound to win one in front of him eventually. I don't think he dislikes me. I just think he keeps finding against me. But knowing that alternative judge can be a useful part of your negotiation. Now, when you get into the ADR, the first thing that we do, and it's a given in most cases, but again, if you don't know your opponent, you want to do it formally, we make sure that we understand that this is a without prejudice basis. I did an ADR 3 or 4 years ago now, 5 years ago, where afterwards, the partner in the defendant's solicitors wrote an open letter saying, in the ADR, you said this, 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 and this. And we made it very clear that if that's the way they wanted to play it, we would advertise the fact that they did not treat without prejudice conversations as without prejudice, and we would publicise that fact. And suddenly they shut up very, very quickly. Next thing is to confirm the parameters. Let's talk about this, let's talk about that. for these purposes, we'll come back, we'll park this idea. Well, we're not going to discuss that today. We can come back to that another time. If we have enough time, we can always come back to it. But set out the parameters, set out the rules for the engagement. Confirm whether you've had any money already, and if so, how much. I had a settlement which we spent 5 hours trying to reach a settlement of £400,000. And the number was 400,000, absolutely £400,000. And at the last minute, we had an argument about how much had been paid by way of interim payments. And we were £1,000 apart, 1,000 in 400. And the claimant said, I'm walking away. I'm going to walk away for £1,000. We've fought 8 hours to try and get to 400, but I'm not giving 399. No, 400, it has to be 400. And we worked out what had happened. We'd paid £17,000, but she'd seen £16,000 because £1,000 of it had been used to pay for a physiotherapist treatment that had never then become part of the claim. So we'd put £17,000 in, but she'd only seen £16,000 come out to the other end because the other £1,000 had been diverted. And once we realised that that was the problem, and we were just moving the numbers around from column A to column B, our settlement of £400,000 was right. Now, confirmed deductions. This is something that's peculiar perhaps to English law, but there are different funding regimes around the world, and we are international today, so let's talk about these ideas. Different funding regimes mean that sometimes some of the damages that are going to come out, it can be paid to the claimant, fall to be paid instead to their lawyers. And there are a whole host of reasons why that might happen. It might be that there's a medical report that you never wanted to disclose, and you said, well, if you want to get a new medical report, then you're going to pay us for the first one. We can't pretend that we're going to get the money back from the other side, so you're going to have to pay that. But there are a whole host of reasons. That's a different lecture, a completely different lecture on what we might deduct. And we don't need to confirm that with the other side, but we do need to understand that with our client. We need to have within our room the understanding that this is what the client will actually see from the damages that are being discussed. And then we can confirm the basis of costs before we start the conversation about how much we're going to pay. And I've not done a slide for it, but it's worth just explaining how these negotiations work, because with Zoom and COVID and normally we would all come to chambers. You remember the photo of Dean's Court chambers at the start. We would have a conference room for the claimant and their team, a conference room for the defendant, and either a third conference room for the lawyers to meet, or a little nook somewhere by the stairwell outside, walking around the local gardens, trying to get some fresh air away from the client, an opportunity for the lawyers to break out and talk face to face, but without getting everybody into one room. And you come in, you meet, you have your conversations, and then you go back to your respective camps and you say, this is what's on offer, this is what we've talked about. And when we do this with Zoom, it works really well because we can use the breakout room facilities on Zoom. And you, particularly with a mediator, the mediator sits there and says, well, I'm just going to move you and you into this room over here. I'll join you in a minute. And they pop up on the screen. You've not moved from your seat. And it's worth saying at this point that I bought a new chair in October. It's not as comfortable as I would like it to be. And I have now invested a stupid amount of money in a gaming chair, which is going to come in the next couple of weeks, hopefully. But if it's good enough for people to sit and play computer games for hours on end, maybe it'll be more comfortable for me to sit in front of my computer, engaging in ADR with other people. So we then have we're in the ADR, we've identified what our rules are going to be, and you need to think about where you want to get to. And sometimes people go into an ADR thinking, well, I'll make 3 offers. They know, because my friend down the pub, my friend down, my mate who was involved in one of these cases last year said, oh, they always make 3 offers. Always, you can reject the first offer safely because they'll make another offer. Sometimes that's helpful. Sometimes it's really not. If your offer is, I'm going to spend this much money and I've offered you that much and I'm not going to give you any more, but I'm going to explain to you why I'm not going to give you any more, then you can cut to the chase. There's a wonderful story about a joint settlement meeting held at Dean's Court about 15 years ago, where there were 3 parties to the negotiation: a really badly injured claimant, an insurer who was potentially on the hook for a lot of money, and the Motor Insurers Bureau, because there were 2 drivers, one of whom was uninsured. And there was a risk that the uninsured driver would have to pay and the Motor Insurers Bureau would have to pay. But if the Motor Insurers Bureau could blame the other driver, then somebody else was going to pick up the tab. And the Queen's Counsel for the claimant and the Queen's Counsel for the defendant, the first defendant, knew each other well, and they had arrived in good time, and they'd taken up camp in the breakout room, and they were having a cup of coffee and some biscuits, waiting for the barrister for the Motor Insurers Bureau to turn up. And he was coming all the way from London, and it was a horrible, wet, rainy day, and the trains were delayed. And 45 minutes after they were due to start the negotiations, this man strode in a coat and hat, dripping wet, and he stood in the doorway of the room. He didn't even step over the threshold. And he said, "My instructions are to offer you £1 million. Take it or leave it. I'm on the next train to London." Turned around and walked away. There's my £1 million. Have it, take it, do what you want with it. But I'm giving you 1 offer, and I'm not going to waste time making 3. And it's worth thinking about the psychology of these offers. Do I want to look at the offer in terms of the big number, the total figure? Or do I want to make an offer that's based on what the claimant themselves will see? Because sometimes you get clients who want a settlement that they want to know that the case was worth £500,000. The fact that they've had £125,000 on account, and the fact that they've had £17,681 worth of benefits, and the end point figure is going to have pence in it rather than be a round number, they don't care about how much they're going to see. They want to know that it's worth £500,000. Equally, they might want to know that the cheque that they're going to receive has this number on it, because that's their end point. They want to know that they can pay the mortgage. They want to know that what they can invest the money in. They want to know what they can spend the money on, and they need to know how much they're going to get. And people have a psychology because there's a round number idea. The reality is, if I offer you £25,000, there's no real difference between 25,000 and 24,950 or 25,050. But £25,000 somehow feels like the right number to lawyers. We work in these big, sweeping, round number type of situations. And that can give some really odd results. Because I once had a client where the offer that was made was 117,000 and something. And when you took off the numbers, it meant that they got £102,426 in their hand. And I said to my client, "What do you think about that?" He said, "I want 100,000. I said, "Well, they're offering you 102,426. And he said, "No, but I want 100,000. "Why do you want 100,000? "Well, I want to be able to tell my mates in the pub that I got £100,000. "Well, tell them that you got £100,000. "Lie." I wouldn't tell them how much you got at all. But he was so focused on the psychology of a round number that he was almost suggesting that we give them £2,500 back, because his little brain couldn't cope with a bigger number or a less standard number. When we're talking about ADR, tempo of negotiation, tempo of the negotiation can be really important. Knowing when to make an offer, know when to speed up, know when to slow down, know when to, the other side is going to stew for a little bit and make them think about this. Are we actually going to make an offer? We can make a decision that we're going to offer them another £2,000 or £5,000 and then sit there and wait as if I'm really fighting my corner or their corner to try and get this set of instructions from my client. And also the idea of final offers. Because from a lawyer's perspective, from a barrister's perspective, there are certain codes that we use, that we have to use, so that we can be straightforward with our opponents. And one of the things that we do, and we drum it into our pupils, if it's your final offer, say, this is my final offer. This is the limit of my authority. And if you say that, you have to mean it. You can't say, my final offer is £100,000. And when they say, oh, well, we wanted 125, you can't go back and go, oh, we'll take that. You can't pretend that you've not said it. It's like watching Who Wants to Be a Millionaire? When the light goes on, you can't change your mind. Final answer. Now, sometimes you get to a situation where your final answer is your final answer within the joint settlement meeting itself. But you don't have to finish at that point. You can come back later on, and we'll talk about that in a second. I want to talk about this slide in terms of types of offer. Just stepping back a little bit, because I think that slide should possibly have been the one before. Forgive me. But we can make offers about all these different ideas. Liability, we can make gross offers, which we've talked about, and net offers. We've also, liability offers, by the way, is to say, you know, I'll accept 10% contributory negligence, or we'll settle for 80% of value. Non-cash offers can be quite important in a joint settlement meeting. An apology, doing an act, something that the court could not order. We talked before about stepping outside the binary decisions that the court can make. Non-cash offers can be important. And finally, just cost-inclusive offers are offers where somebody says, well, I will give you £100,000 for your damages. And they say, oh, that's not enough. Well, hold on, how much are your costs? Well, we've spent 85,000. Well, I'll tell you what, I'll give you 175 all in, and you split that with your client. Those can be really difficult decisions, because you don't want that sort of offer as a claimant, because it drives a wedge between you and your client. But sometimes you might want to just get rid of the whole thing from a defendant's perspective. I've got this much, that's how much I'm prepared to give you. After that, I'm going to walk away. That's my final offer. So, outcomes. Which is where I was talking a couple of slides ago. Sometimes we have a signed order. If you're already in court proceedings, you need a document that goes to the court that says, we've agreed, judge, we're fine, we're done, thank you very much. Sometimes we have a memorandum of understanding. If you've not actually started proceedings, you can just have a written agreement. This is what we've done, so that we don't need to litigate. Sometimes you don't settle, and we agree to have ongoing negotiations, and those can take different forms. They don't have to be a formal meeting. They can be phone calls, emails, WhatsApp messages. We are living in COVID times and 21st century. Sometimes people make time bomb offers. That is to say, an offer that's open for acceptance for a particular period of time, after which it's taken off the table. And very often you get to a joint settlement meeting where you say, well, look, if we don't settle it today, my offer is going to be £200,000. But if we settle it today, I'll give you 210. And you're trying to hold out that carrot to the other side to try and get them to settle it. But ultimately, the outcome can be, go home. We're done. We can't settle it. We'll come back and meet another day. And if you don't settle, what happens? Well, you can't rely on what you've discussed, because it's all without prejudice. But you can always revisit that negotiation. You can always pick up the phone and say, you know what, I've thought about it. My client wants to have that offer after all. Is that still open to you? You're not bound by your last offer. It might have been a time bomb offer. You might turn around and say, well, actually, I'm going to offer you less now. You might have to go to court. Alternative dispute resolution does not necessarily resolve your case. But the real question is, was it a waste of time? Because you will have picked up a whole host of nuances about the other side's approach. And if you're from a defendant's perspective, you might be thinking to yourself, well, are our differences irreconcilable? Do we know what we're actually trying to achieve in this? So in a nutshell, ADR is without prejudice. The form of ADR depends on the case. Is it going to be a mediator? Is it going to be an arbitration? Is it just going to be picking up the phone and having a conversation? It's not a binary decision-making process. There are a whole raft of, there's a whole spectrum. Any settlement is available to you if you're engaging in ADR. Any outcome is available. Expectation management is absolutely key. Going into ADR with your client expecting £1 million where it's never going to be worth it is never going to lead to settlement. And be prepared sometimes to do the negotiation, but also be prepared to walk away. So my advice, you don't have to settle. Sometimes it works and you get an absolutely cracking result. Ladies and gentlemen, I've talked for just over an hour without, I hope, much deviation, hesitation, repetition. That's the third book, the New Pupillage Workbook. But I've been David Boyle, and thank you ever so much for joining me this morning. And to the 608 of you who are still with me, despite the fact we've had an hour, thank you very much for your time.
Thank you, sir. So without further delay, I would like to start with the question answer round. So while you were speaking, we have received around 100 plus questions. So I don't think that you will be able to answer all of them. So I'll read out a few of the questions and I hope that you can answer some of them at least.
Let's try. Let's see what we can do.
Yes, sir. So we have one question from Mr. Abhishek Pratap Singh. So he asks that how is ADR used at EPA and what is your arbitration philosophy?
I think, can I deal with the arbitration philosophy first? Yeah. You have to, I think we come back to this idea of drivers of behavior. I did a post on LinkedIn a few weeks ago, which was, what sort of advocate are you going to be? Are you going to be forceful? Are you going to be timid? Are you going to be analytical? Are you going to be bombastic? And the answer is, it's not about you. It's not about what you want to be. You're there simply as a facilitator, as a catalyst. So your approach to arbitration, your approach to ADR, whatever it's going to be, is always going to be client-led. You have to have that understanding that before you engage, does your client want to settle it? Does your client have a bottom line? We come back to our rule of three, and as much as quickly and with as little risk. Is your client risk averse? Is your client time averse? Is your client money orientated? And those will define your approaches to arbitration or ADR generally. And all of those different factors that we've talked about today are part and parcel of the recipe that goes on in your mind before you start, because you might think, I've got a really strong case, but my client just wants to settle it, and the offer that's being made is a nonsense one. One of the big difficulties comes where you're on perhaps a no-win, no-fee agreement, and it's a case where you're thinking to yourself, hold on a second, I've put a huge amount of time and effort into this case. There's an offer now. Is it really enough? And that need to isolate your own thoughts and your own position and be uncaring about that and being objective for the benefit of your client, it is something that lawyers are trained to do, and we do quite well. But I think sometimes you do have to stop and think and say, hold on a second, am I allowing my own personal position in all of this to be a factor? And how do I cut that out? How do I rip that away and focus on the client's needs so that I can give them objective advice? And I think that we now have a situation where ADR is going to be more and more common. whether in terms of international or local disputes. And when you actually ask somebody what they want out of their dispute, most people want resolution. The benefit of actually settling a case is huge, and there's an adrenaline surge when you're in these negotiations. And I like to keep a client there for 10, 20 minutes after the end of it, just to let them start to come down. And the number of times that a client will turn around and say, oh, I feel, several pounds lighter, the weight of, we talk about the weight of the world being on our shoulders. Resolution can lift the weight from the shoulders of these people. So I think that's probably how my philosophy of arbitration. I hope that gives a better idea. There's another half to the question, but I can't remember what it was. Forgive me, I probably didn't understand it anyway. What have we got? How ADR, I'm just looking at this. How is ADR used in consumer dispute resolution? Well, the answer to that is exactly the same as with personal injury. You might have a contractual obligation to engage in ADR, so you've got a pre-existing obligation to engage in ADR. But the principles are the same. We need to sort this out, lads, because we need to be here and we need to continue our negotiations. We need to continue our ongoing business relationship. We still need to be friends on Monday. And actually, sometimes ADR is a good way of ensuring that you are still friends on Monday. Whereas an arbitration with its finality and its need to give evidence or need for determination can be more destructive. So that's something that is something that hopefully is useful. I'm just looking to see what other questions we've got. Have you got anything that you've picked out particularly? Oh, you're muted. You're muted. That makes life easier, obviously. I can just carry on talking. You're back. Rashi, you're on mute, I'm afraid.
Rashi, you're mute.
It was a really good point, but I was lip reading, but it sounded really good, but I didn't quite pick it up.
It was good for you, of course, and for us. But there are certain participants who have asked questions which do not match the theme of the event. So I request them to approach sir with his email or on LinkedIn. Sir is always available on LinkedIn. So the participants can ask their questions there. Apart from that, sir, we have a question from one of our participants that what do you think is the future of online dispute resolution system amidst this pandemic?
I think we were talking in the UK about going online and being more online last year, and everybody said, oh, it will never happen because you have to have investment and you have to have time and you have to have accessibility. And I think that one thing that the pandemic has clearly done is accelerate. Normally when we see technological advances, those technological advances come in the context of war. We have to be honest about this. Engineering advances, they come out of necessity. And what the pandemic has done is rendered necessary online communication, online negotiation, online litigation. And I think that what we will see is a move towards online dispute resolution far more. The difficulty is in assessing people's truthfulness, perhaps, and integrity when you're using a webcam. We see these pictures of people who turn up and they're wearing a suit and tie, but they're actually wearing a pair of swim shorts or something on the lower body. I assure you, I'm wearing a suit today. But the idea that we can assess somebody's credibility online, it is far more difficult, whether for students doing exams online or for litigants going to court and giving evidence online. So if you've got a dispute where credibility is an issue and the judge wants to be able to assess the body language, the demeanor of an individual, I think we're still going to struggle with an online litigation process, although obviously ADR is something that we can work with. The cases that I've done using online technology since lockdown have been advocacy exercises, so civil appeals, where we did a trial and we're now coming back and we're having an argument on the law, and those work beautifully. The idea that you've got you, your opponent, your judge, you've got a close-up of the judge's face is really quite interesting, because those micro nods, those micro expressions, it's like playing poker, but you've suddenly got a really good view of the individual that you're speaking to. Somebody I was talking to yesterday said, now everybody's in the front row. With all the people who are on a Zoom conversation are in the front row, so you get this vision of the judge. And I think if you're using advocacy and it's simply an advocacy exercise rather than a witness evidence-based exercise, online courts will work really well. We've been doing stuff by telephone in the UK for 3 or 4 years now for administrative hearings. But if we're doing appeals, I had one the other week where it was a 90-minute appeal. The judge was in Cardiff. If I'd driven to Cardiff, it would be 4.5 hours drive each way. It would have been an overnight stay. And, instead I just had to wake up, get a copious amounts of coffee down me, put a suit on and sit in front of my computer. And I've saved myself 9 hours on the road and an overnight stay. Whether people will want to pay me the same or want to pay me pro rata for doing it from home is another interesting question. But I think that COVID is forcing us to confront these ideas. And I think that if we can make it work effectively for the low end litigation, and focus perhaps on the high end litigation being the stuff that's heard face to face, where it's more important that we get it right, that I think is a good idea. I think it will drive down the number of cases being heard, and I think that it will, coming back to our drivers of behaviour, it will force claimants and defendants to be more realistic in terms of their hopes from the litigation. I think people will avoid going to court for those reasons.
Thank you, sir. Sir, I'll be taking one last question. That is one of the most common question that I can see in the chat box, is that what do you think is the ideal qualification for a person who wants to practice ADR in UK and choosing ADR as for LLM as well as a career?
So being a mediator, in fact, or being an arbitrator, I think you have to make a decision if you want to be a mediator or an arbitrator. You're doing different, there are different qualifications that you would do. And you don't need to be a lawyer, but I think having a basic legal understanding is obviously fundamental. I think one of the things that I think is really important is that you don't need to be a lawyer start, middle and end. You don't, I did sciences for A-level. One of the reasons I enjoy accident reconstruction is it allows me to dust off my applied maths and physics and use those techniques and use those ideas and skill sets. There's international institutes of arbitration, and you can get your certification from doing that sort of thing. But I think you have to think about your skill set. You have to understand that to be an arbitrator or to be a mediator, you need to be able to engage with litigants. You need to have their respect. You need to gain their respect or be able to gain their respect and start afresh and build relationships. And I think that being particular mediator is something where you either have that ability to talk to people and have that ability to engage, or you don't. But it's really quite important that you maintain a distance from the litigants. And I call it uncaring empathy. That idea that you can empathize with a person's situation, but really don't care about them as an individual. It sounds dreadfully callous in many ways, but if you start getting engaged with the individuals and their lives, first of all, it's very easy to do that because you're living life with the volume turned right up. You're talking to people whose lives have been ruined, and there are catastrophes, but there are also fabulous stories that come out of all of that. But if you get too engaged with that, it's very, very difficult to switch off afterwards. And you can get sympathy fatigue. You'd be too nice to too many people. And that ability to switch off, I think, is really important. So when you ask the question, what are the best qualities and best ways of becoming a mediator? I think you have to be the right sort of individual in the first place. And you have to have that self-awareness of whether your skill set will lead you into that, or whether it becomes too difficult. Because one of the difficulties with mediation is that you mediate by being engaged with the litigants, by talking with them and bringing them together. And then to be able to just flick a switch and walk away is something that many people really struggle with.
So that was our last question, sir. But the participants have been thanking you all throughout the session.
That's fabulous. That's very kind of them. I hope they've enjoyed it as much as I have.
Yes, sir, indeed they have, because that's what all of us can see, that it is very difficult to find the questions because most of the participants are thanking you because most of their questions were already answered in the session.
Oh, I shall save those for later. You'll have to send me a copy, and I shall sit and read them at leisure.
Definitely. And those participants whose questions were not answered, I would request them to join sir as a connection on LinkedIn, and sir is 24/7 available there.
Absolutely. Well,
24/6.
I had a wonderful conversation yesterday with an American filmmaker called Tiffany Schlein, who believes in what she calls tech Sabbath, that on a Friday night for 24 hours, the whole family put all their screens away and they go and live like Luddites. And she said that in lockdown, it's the one day that they don't feel like they're in quarantine.
That's what we will try to follow in our daily lives. It's very difficult for the students to follow. So I request Dean sir to kindly conclude the event.
Okay. Thank you. Thank you, Rashmi. After so detailed and comprehensive lecture, I cannot dare to conclude it. But I will say, Mr. David has given the complete idea of ADR in his short lecture. Mr. David, this is in the root of Indians, right from the Vedic period, which is considered to be the most ancient period. We have been the concept of ADR in the name of Panch Parmeshwar. Mr. David, that Panch Parmeshwar means the decision or resolution, amicable solution of the dispute by the eldermen of the community. They were called Panch here, okay? And Panch Parmeshwar is the eldest person of the village. So whenever any dispute used to be in village or anywhere, they all used to go to the Panch Parmeshwar for resolution rather than going to any court, police, king or anywhere. So that is what is in the root of Indians. But when you have explained it, all the method, arbitration, mediation, settlement meetings, negotiation in very nice way, then that I was just recollecting what we were taught in our childhood, that what the Panch Parmeshwar is. And the beautiful part of that system was the trust in the person who Mr. David has also stated that part must be there, because the eldest person of the village, he should have the dignity, vision, character, and everything so as to have the decision acceptable by every person in the community. So the same concept. Now, Mr. David, I will tell you, gradually and slowly, again it is coming up in our country. And even the amendment has been taken place in Civil Procedure Code, Section 89, right? And plea bargaining and all other concept, arbitration, although we are fearing that this arbitration is also stepping into the shoes of litigation. But anyhow, we are also following that, and now the time has come when we have to follow it, and we have to go for alternative dispute resolution system. And but I have noticed, and I will regard Mr. David for that, he started his speech from his professor and the place and everything. For that, I salute you, that you also follow the same tradition which we have been taught and established in this country. So with this, I thank you very much, Mr. David, from the bottom of my heart, on behalf of all my students who have been contacting you every time, and you have given them acceptance, and this is the result and today's webinar. So thank you very much. Thank you so much.
Thank you very, very much for having me. It's been an absolute pleasure.
I will also thank the Deputy Director of this TRD, Professor Poonam Rawat ma'am, who is Principal of Law College Dehradun and guiding their team. And I also thanks and appreciate Akansa Bhatt, Rasi Jha, Naina Bhatt, and their entire team who has arranged and organized so beautiful and meaningful webinar and talk today. Thank you very much. Thank you so much, everyone. And Mr. David, one more thing. I'm recollecting, when I go through your work, you have written a lot. So now I will call, this is your college and your university. and we have a very renowned journal here in the name of Dehradun Law Review. You can see on website DLR, Dehradun Law Review. And I will request you that some contribution in this edition from now my dear Mr. David Boyle. So
that would be absolutely wonderful.
I will send the formal request, but this is my public request before everyone, that this Dehradun Law Review should have this time one paper from Mr. David Boyle.
I shall do it as soon as ever possible.
Okay. Thank you so much. Thank you so much.
Thank you. It's been absolutely wonderful, and somehow we've still got nearly 500 people. They need to go home. If it's 11 o'clock in the UK, it's Friday afternoon, and please let them go. Please have a wonderful weekend. Keep safe, every one of you, and I look forward to seeing you on the next Zoom, or maybe even in India. We never know, but I wish you all the very best going forwards.
We would love to host you, sir. Just a last thing, the last token of formality that has to be done, that is a vote of thanks. So I request Poonam ma'am, our principal.
Thanks is already given by VC sir. Still, it's my honor and privilege to propose vote of thanks on behalf of Law College Dehradun to today's keynote speaker, Mr. David Boyle, Barrister, Dean, Coach Chambers, Manchester, England, who enlighten the participants on a contemporary issue, a guide to dispute resolution process in a very simple way. It's really going to help the participants who are academicians and future lawyers also. It's very insightful, sir. My thanks to Vice Chancellor, sir, Professor Dr. Rajesh Bahuna, for his unconditional support. And my special thanks to all the participants from all over the world, and a special mention of Akanksha Bhatt, Nana Bhatt, and Rashi Jha, and whole of the office bearers of TRD. Thank you very much.
I shall let everybody do something far more useful than listen to me. As I said before, I wish you well and all the very best. I look forward to the next one.